Hi everyone, this is Eva Bakun welcoming you all on behalf of Clarion Gaming back to our sports betting webinars. After a few months break, we are back with another webinar series, this time leading up to our next and widely anticipated sports betting show that will include both a conference and an exhibition, ICE North America, taking place on May 13th, 15th in Boston. So look out for an email from us coming your way very soon, announcing an exciting and different conference agenda, and also its speakers, many of whom you won't really be able to meet anywhere else. And we should be releasing more information next week. So this new webinar series is being opened by our experts' interpretation of reinterpretation of the Wire Act that was just very recently, less than 2 weeks ago, published as a surprise by the Office of Legal Counsel. At the beginning, I really want to thank all our presenters who gave us their availability on such a short notice to share their opinions today on the impact of this new opinion. But before I hand over to them and also to the moderator, Brendan Bussman, I just really wanted to let you all know that this webinar is being recorded, which means that you will also have access to it afterwards and will be able to re-listen to it. The webinar will last around 40-45 minutes. Well, the presentation during the webinar will last around 45 minutes. And we will leave the remaining 20 or 15 minutes for questions. But you can ask your questions throughout the webinar, and you should see on your menu a question functionality, which you can use to type your questions. Well, thank you so much for tuning in today on this Friday morning / afternoon. And I am handing now over to Brendan for the webinar.
Thank you to everybody for joining us this morning and this evening if you're in in Europe. We appreciate your interest in this very relevant and hot topic within the industry. I'm going to take a moment and let our esteemed panelists introduce themselves. We have a great group of people here for you today that offer a not only great expertise but a wide perspective considering each of their areas along the way. And if our panelists can take a minute to introduce themselves, I'll start with you, Tony, and then we'll just go through real quick, everybody, and then we'll get started right away. So Tony, why don't you just say a few words about yourself?
Sure. So my name is Tony Cabot. I'm a professor and distinguished fellow of gaming law at the University of Nevada Boyd School of Law. Prior to that, I practiced gaming law, a considerable amount of it in internet gaming in the 36 years prior to becoming a professor.
Very good. Very good. Gordon, why don't you take a moment and introduce yourself?
Thanks, Brandon. I'm Gordon Medenica. I'm the director of Maryland Lottery and Gaming, and we operate the Maryland Lottery and oversee our 6 casinos in Maryland as well. Previously, I was the director of the New York Lottery, where we also oversaw the lottery and our lottery casinos in New York.
Very good. Barry?
Great. Thanks, Brendan. I'm the senior gaming analyst at SunTrust Robinson Humphrey. We're an equity research focused firm. And, you know, I've been on the sell side for about 8 years now, covering mostly U.S. domestic regional gaming operators, gaming REITs, and gaming technology companies. Before joining Wall Street, I worked for IGT and MGM Resorts in M&A corporate finance capacity.
And our final panelist, Brant, you want to mention a little background on yourself?
Absolutely. Good morning, Brendan, or good evening, depending on where you're at. Brant Iden, state representative from Southwest Michigan, a town called Kalamazoo, chairman of the Ways and Means Committee, heading into my 3rd term in the state legislature, and author of the Online Gaming Act of 2018, which unfortunately received a recent veto, and looking forward to moving into into the discussion as well as into online gaming sphere again in 2019 and continued rollout of legislation there.
Thank you. Thank you all for your brief introductions. Let me just set the stage a little bit here before we roll into our agenda. Obviously, what brought us all here today was a memo that was released by the Department of Justice that in the brief that we issued with Global Market Advisors reversed the reversal, if you want to call it that, over a 2011 memo that the Department of Justice issued that was largely initially driven by the lotteries as well as the gaming industry. And I think the past 10 days, 12 days that has transpired has a lot of people wondering what's next. What are the implications? What are the enforcement levels that will potentially come into play? That was the secondary memo that was issued on Tuesday of last week. But sort of maybe, Gordon, if I can send it over to you first to maybe set the stage of how we got to 2011 before we got to 2019, and then we'll start going through our agenda and definitely leave a lot of time for questions and answers from the audience.
Great, thank you, Brendan. Yeah, I was the director of the New York Lottery, and back in around 2009, we were dealing with a lot of issues, and a lot of the issues that had been triggered by the passage of UGIA, which was very important at the time. The New York Lottery had been taking lottery subscriptions online probably since the 80s, and the UGIA bill actually created some problems accepting payment, particularly with debit and credit cards. And so we were struggling with the credit card companies and trying to figure out ways of getting payment processing through without some exorbitant fees that the credit card companies at the time used to charge for things that were considered gambling products. So about 2009, we decided to go straight after the Wire Act. And originally, our primary argument was based around how the back-end processing for all lotteries really in the United States are done. There are really just three primary vendor companies that do central systems, GTech, now IGT, Scientific Games, and Intralot. And we produced a map of the United States that showed how all of the processing of lottery transactions occurred and how signals were bounced off satellites that ended up at data centers that were in other states. And there was just this spider's web of lines crossing all kinds of states that really dealt with just anyone who was, going and buying a lotto ticket at a retailer. Most people don't realize that when they're buying a ticket at one of those lottery terminals, that transaction is actually going back to the central system before it's confirmed. And again, in real time, the player doesn't even notice that delay. But that kind of processing that was taking place was really technically in jeopardy of the way some people were viewing UGIA, and certainly the way that we thought that the payment processors would limit our ability to expand that. So the original intent wasn't so much to promote iLottery as to protect the way our systems were already operating. We made that argument to various members of the DoJ at the time. We also then found friendly allies in the state of Illinois, and we encouraged them to also submit a brief supporting our position on the Wire Act. And we would check in regularly with DoJ, didn't hear anything, and then surprisingly, the day before Christmas Eve, 2 years later in 2011, we received the letter from DoJ. And by the way, all credit to the general counsel of the New York Lottery at the time, Bill Murray, who really was the brains behind the whole effort. And so that 2011 opinion was expressed in a letter to Bill Murray at the New York Lottery. And at that point, we were on our way thinking that, okay, now we know where the future lies, and it gave a lot of comfort to a lot of initiatives that the industry wanted to pursue at that time.
Thank you for that overview, Gordon. I'm going to kick it over to you, Tony, a little bit. Does this take us, does last week's action, where does it put us in the big scheme of things? Are we pre-2011? Are we somewhere in between, or are we clear back in the 1960s off of where this goes, and sort of what happens next?
Well, there's two things that occurred in the opinion that I think are important. The first one was the reinterpretation of the Wire Act to apply not only to sports, but to all forms of gambling. So when you do that, that brings you back to before 2011, basically reversing the other opinion. But they did something else, which I thought was particularly problematic in the opinion, is they went out of their way to interpret a provision of the Unlawful Internet Gaming Enforcement Act, which defined intrastate wagering, where the sender and the receiver are in the same state, regardless of how the communication might be routed, to say that that does not apply to the Wire Act, insinuating now, as they have in the past, but now very clearly, that not only is all forms of gambling now subject to the Wire Act, but anybody that uses any type of communication, i.e. the internet, potentially mobile data systems, or anything that effectively remote wagering, is now in their interpretation illegal, i.e. applying to intrastate wagers as well. So I think it actually goes further than reversing the 2011 opinion.
As part of that, Barry, what are you seeing from an investment perspective and someone that looks at the financial side of the gaming community? Are you seeing an impact off of what exists there?
Well, I mean, I think like Tony says, it just depends what the interpretation is. If the interpretation is simply the purchase, pooling of poker liquidity across states or purchasing of iLottery tickets across states, it's fairly immaterial. I think, the initial thought was confusion, and the stocks on the day of the announcement were fairly volatile, but most of them finished up more flattish because it started shifting to more just crossing state lines in a direct betting capacity. And if that is the case, it's fairly immaterial. And frankly, look, to be completely honest, internet online gaming hasn't really taken off the way that maybe Governor Christie had suggested around 2011 or 2012. So that really hasn't been a focus of investors. I mean, sports betting is still sort of seen as a huge potential, but I don't think there's anything in the stocks today. Probably after PAPSA was repealed, there certainly was a lot in the stocks, at least the U.S. listed stocks, on expectations for sports betting. But a lot of that's come out as the stocks have sold off into Q4. So I think right now there is, a view that this may not be hugely material in the near term, but it does somewhat question just how stable it creates uncertainty, and the market certainly never likes uncertainty. But I don't see much in the stocks on this today.
Brant, from your perspective, obviously you're a state that came very close to jumping in at the end of last year to the online space, have a desire to move forward. How does this latest ruling affect how you look at legislation going into this session and what others have done? We've recently seen Pennsylvania issue the memo they did, I think it was last Friday, off of some changes they'll have to do. But from a legislative perspective, what does this mean from an online? And then I sort of want to pop back collectively to the group and talk about the sports betting aspect and other forms of gaming.
Sure, absolutely. Well, at the end of the day, I really don't think it's going to impact our efforts to move forward at all. First and foremost, this is just simply an opinion. That's all it is. And it would take some enforcement. And I'm not sure that the federal government has the desire to start back in fighting the states on this again. The states are going to step up, especially those with iLottery. I mean, if you think of Michigan, we have a very robust iLottery, a tremendous amount of revenue, plus the upside for potential revenue on the online gaming piece, as well as sports betting. We've seen the revenues from New Jersey there. I think that that's just the beginning. We haven't seen the bets come in from the Super Bowl yet, which we're going to see here in the next week or two. Those are started, but certainly as we get closer to game day, that revenue is going to begin to materialize. And my colleagues in the state and others are saying, look, we recognize that this just isn't about the revenue, that this is also about the consumer protection piece. It's going on in the marketplace. Is the federal government going to really step up and challenge us at the end of the day? Probably not. This could be viewed similar to how states are dealing with marijuana legislation, and the federal government is just sort of hands off. Now, I realize there's some other implications there, but at the end of the day, is the federal government going to approach us on this? I'm not really sure. I believe that this is really set up to slow states like Michigan, West Virginia, others that have begun to take the lead on this. This came out to slow us down, and there's no desire on my end to do that, nor do I think that there's any desire from my colleagues. If you remember, the bills that came out of the legislature came out with tremendous bipartisan support. Veto-proof support, in fact, and had we had a little bit more time, we could have been discussing an override. But we're going to get right back on the horse and go after this again.
Very good. I know that Barry mentioned the emerging sports betting market in his comments, and Brant did as well. Tony, from your perspective, what does this mean for, either existing DFS industries, the emerging sports betting, the existing sports betting as it happens in Nevada? I was pinged by an operator last week going, if our app gets put off and put into a tower system that goes off of a tower in California or Arizona, is that a violation? What are the implications for existing jurisdictions and emerging on some of these other areas?
Sure. So I think they're really two separate topics. One is fantasy sports, and the other is sports wagering. Regardless of this opinion, I think everybody agreed that the Federal Wire Act applied to bets or wagers on any sporting event or contest. Obviously, daily fantasy involves sports, so their exemption from the Wire Act is really based on a completely different set of legal principles, and that is whether or not what they're doing is a better wager. And the argument that they've had, which obviously has been successful because they're a thriving business, is they're not in the business of betting or wagering because fantasy sports is a game of skill versus a game of chance, and bets or wagers are when you risk something of value on a game of chance. So I don't think it impacts daily fantasy. But when we get to sports, that's a different story. And if they take a broad interpretation, as they insinuate they're going to do in the opinion, then it could negatively impact mobile wagering, which, if you follow sports wagering, in Nevada, for example, is now over 50% of all the revenue is done off of mobile wagering. Now, I'm not saying there's not solutions that they potentially could use to make sure that there's no intermittent routing through other states. But it's something that I think they're going to have to look at very closely to make sure that is not the case if they want to be in compliance with this opinion. And they need to convince the payment processors that their processes are such that they're not in violation of this directive.
From a lottery perspective, Gordon, how does this affect sort of your future operations and the industry as a whole from your perspective?
Well, I think there's certainly a chilling effect that I believe this opinion has had. And Tony made the important point that the chilling effect may be felt more from the payment processors than from the lotteries themselves. There's certainly been some discussion in the press that the multi-jurisdictional games, the big ones, Mega Millions and Powerball, are somehow uniquely challenged by the DOJ opinion. I don't think that's the case. I think those games, frankly, are processed the same way any other lottery game at any other lottery would be. So I think the risk to the big multi-jurisdictional games is the same as the risk to the lotteries themselves. And again, back to Tony's point about where this current opinion has sort of extended or impinged on even the UGIA protection about where a payment is processed. As long as it begins and ends in a state, it's considered an intrastate transaction. That is no longer the interpretation. So again, at this point, it'll depend on enforcement and or prosecution. I think for most lotteries, it's business as usual. There are about 6 lotteries that currently have active iLottery revenue-generating products, Michigan being one of the leaders. Certainly if one of those operations is challenged or shut down, we shall see. But as was referenced earlier, the chilling effect is already there. I think we saw that in Pennsylvania with this notion that now any of these emerging iLottery, iGaming operations, they're calling for all the servers to be based within the state of Pennsylvania. Of course, in New Jersey, iGaming, I think they required server location in the state anyway, but that was not for these legal reasons. It was for other reasons. So I think our current operations are probably not going to be the first line of defense or the first line of challenge out of DOJ, but certainly to the expansion of iLottery that we'd all like to see, that's certainly very relevant. And also to the extent that states like Maryland are looking at getting into sports betting, the implications, particularly on mobile, and some of the decisions about what to get into, what does sports betting mean? Will it just be at bricks and mortar, at the casinos, or at the horse race tracks? Those kinds of points. You cannot ignore the mobile option because that's such a big part of where the revenue potential lies. And when you have this kind of an opinion out there, that may have a chilling effect on lawmakers when they're thinking about what kind of betting options do we really want to offer in our state.
You bring up a valid point where I know that, where does mobile, go and that aspect. And I know there's some operators that believe mobile only exists within the 4 walls of a brick and mortar facility. But how does this, I'll turn this over to you, Brant, that's obviously looking at not only online but sports betting. How does this potentially change the paradigm in states like yours as you're looking to legalize sports betting within your state along the way?
Well, I want to address Gordon's point about the servers and that particular notion that things need to be located within the state. When we originally addressed the Online Gaming Act of 2018, we made very explicit language to state that because of our concerns about expansion, because of our constitutional concerns, we specifically put in the legislation that servers and other technology for applications, mobile applications, online, what have you, all need to be located within the walls and the confines of the brick and mortar casino, located, of course, within the state, sort of modeling that off New Jersey legislation. I think that is going to be, again, key going forward, again, with the plan to reintroduce the same language that made it to the governor's desk in 2018 in Michigan again. I believe that is key. Obviously, as we know, in this sphere, there is a highly likelihood that anything we do will probably get challenged and end up in the courts anyway. And as a legislator, all we can do is say, let's write this so that we believe that we can basically meet any sort of legal challenge to the best of our ability. But if I was a betting man, and I am, I would say that this will probably, no matter what we do, there will be probably likelihood of a court challenge going forward. Now, whether or not that impacts my colleagues' decision as to whether or not they move forward with the legislation is yet to be seen. It didn't in 2018. Obviously, new executive, crop of new legislators in both the House and the Senate. A number of my House colleagues did go to the Senate, who are already on record as in support of the legislation. But again, that being said, it is something that we'll have to contend with, and the best we can do is try to protect ourselves with the language in the legislation to make sure that we can withstand a court challenge to the best of our ability.
I'll open this up for the collective group. Brent brings up a valid point of sort of what's the next step off of this? How do things go forward? And I think obviously we've discussed enforcements. One of the things that we're not sure how that's going to play out, other than we've got less than 90 days to see when they start that level of enforcement. But what's the likelihood of a legal challenge to this memo, or even so much of a legislative change to the Wire Act or anything else along the way?
Well, Brendan, I think obviously there's two paths to resolution, one being the courts and one being the legislature or the Congress. Clearly, it'd be a very clean and quick thing to just repeal the Wire Act, which is an archaic 58-year-old piece of legislation anyway. But given what's going on in Washington these days, I think the notion of a legislative solution may be a long shot. And on the court option, the question is whether or not we will preemptively see lawsuits, as you were asking earlier, or whether we will wait to respond to a court challenge based on a enforcement action and potential prosecution. Both those things will take some time, though.
So this is Tony Cabot, and my preference obviously would be for someone to step up and actually challenge this opinion. Now, I'm not sure exactly how what form that would take, but it would probably be some type of declaratory relief action, probably by one of the states, with the other states joining in to support it. Now, the reason I think that's the better move is because, first, the opinion's, I think, just basically wrong. I think that there's a extremely high likelihood that the states would prevail in the courts for a lot of reasons. One is this opinion says that it's unambiguous that it applies to more than sports. That is just silly. The Department of Justice in 2011 said it was unambiguously only applies to sports. So they have to take a huge leap over their last opinion. There's been two circuit courts that have agreed with the conclusion of the 2011 opinion. So the overwhelming weight of precedent is there. And, frankly, just common sense, when you look at it, would help dictate the results here. So the reason I think that's the better move is because not only the high likelihood of success, but it takes a lot of the uncertainty out of the market. I think someone can go in the next 90 days, probably convince the district court to file an injunction to maintain the status quo. And, frankly, this is not a very complicated case. It's either going to be the interpretation of the 2011 opinion or the interpretation of the 2019 opinion is going to prevail. There's not a lot of evidence or anything else. So I think it's a relatively straightforward case that the states would win and take a lot of uncertainty out of the marketplace.
Tony, I have a question back to you. Do you think there are any other players other than the states themselves that could initiate such a lawsuit?
Yeah, is that directed to me?
Yes.
Yeah.
Okay. Yeah, I think the answer is yes. I think that there is a significant amount of companies that have invested millions and millions of dollars in infrastructure and employees and everything else to supply the industries. And I'm talking about a lot of different industries too, not only poker, but internet gambling, potentially sports wagering, that have relied upon that 2011 opinion, who are being substantially harmed. And I think there's a reasonable basis to believe that they would have standing to also challenge the opinion.
One thing, before I go on to the next question, I'll remind the audience that if you do have a question for any of our panelists, to please type it in on the question portion of your screen today. I know we're starting to build up some questions. We'll go to those here shortly, but back to our panel real quick. I think one of the things, and I don't remember, Tony, if it was you or Gordon that mentioned this, and I'll open this up to everybody that's on the panel. We went back to last May when the Supreme Court ruled basically on a states' rights issue with regard to PASPA, and we've talked about that as being one of the things off of this. Is there an overarching desire, you think, to sort of force this even more from that level, as opposed to letting states prevail in what they're doing, and that could ultimately lead to federal gaming regulations? Or is that completely out of the mix, out of those that were behind the 2019 memo? I'll open that up to anybody there.
Well, Brendan, Brand here. I will say this. I mean, the likelihood is just. I just don't think it's going to be there. I mean, what we're seeing in D.C., and I think Gordon referenced this earlier. I mean, this is not something that I believe is really on the minds of folks at the moment, as they're dealing with many other things that are coming up in D.C. right now. And again, it does come back to a simple states' rights issue, and I understand that sorting it out federally might make it easier for everybody. But the whole point of New Jersey getting involved in this was to say states control gaming. States have always controlled gaming, and we're going to be able to do it better than federally as a whole, and not to mention the unique challenges that each state has as it relates to gaming. I mean, I've got 3 commercial casinos in the state of Michigan, 23 tribal casinos, a constitutional amendment that allows for those 3 commercials to operate, 23 very unique compacts. And sure, a federal law may or may not help the problem, but the likelihood is just not there, in my opinion.
Yeah, but it does raise the specter of be careful what you wish for, and we're aware, of course, the attempts at federalizing some issues related to sports betting, and so that I think it's an important risk, and it's another thing we have to keep an eye on. So we're not trying to trade off our state's prerogative on gaming policy for some sort of federal jurisdiction. We really just want this opinion to be backed up or reversed to the 2011 level. To the earlier also about Brent, how Michigan is sort of protecting itself by requiring the server location. Back to the original lottery argument against the opinion was. I don't think it's even practical or economic for the lottery vendors to completely rejigger the entire central technical system of the lottery industry in this country. So that is not the work of a moment. It's a huge, unnecessary investment if that were the course to be taken. And I think that would be a major point of resistance.
One thing that I think everybody has mentioned here, just in general, is obviously the desire to figure out what enforcement would take place in that. If you any of these, I'll first kick over to Gordon from the lottery perspective. You know, if you're advising your institution or any other lotteries along the way, and even so much as gaming operators, what would you tell them what they need to do in the next 90 days, assuming there isn't any sort of litigation that comes up or any sort of legislation?
You know, I don't think there's much proactive action that could be taken by lotteries themselves. I think we need to rely on common sense that we would not be at the vanguard of any enforcement action. And again, you know, existing lottery operations, the lottery industry is an $80 billion industry in the United States, generating over $25 billion for good causes. I think it would first of all be a massive political mistake to begin any kind of an enforcement action against lotteries that are just too well entrenched and too much part of the fabric of how states operate. You know, in Maryland here, we're the fourth largest income source for the state. These are significant amount of money, and states rely on their lotteries to raise those funds. So my guess is that any kind of initial enforcement action may occur more at the fringes of our industry, if you will, against players that are, you know, relatively invisible politically or have less clout, let's say. However, I think we need to protect those folks just as much as we protect our core businesses, because I think that could be the thin edge of the wedge.
Yeah, and keep in mind that the Department of Justice, in the past, when they've done enforcement action under the Federal Wire Act, has often targeted those peripheral players. So, you know, back in the mid 2000s, they went after, you know, some of the internet providers like Yahoo and others for carrying ads for gaming sites, and threatened that unless they paid a lot of money under a non-prosecution agreement, they were going to get prosecuted. They did it with magazine advertisers. They did it with a whole bunch of other people, including payment processors. So, you know, they can use something short of prosecution, which not only raised a lot of money for the Department of Justice, but also intimidated those players who are necessary to support the industry without going after the industry directly.
Barry, is there anything you see from an investment perspective that you see on the horizon that may or may not be a concern as things play out here over the next 90 days?
I mean, look, I think that the question is unintended consequences, right? Like at the end of the day, states have budget gaps that they need to plug, and they look to gaming, and especially with SALT deduction limitations being reined in. So, you know, if you're sort of backing away from, online, iLottery, even sports betting, I guess it just begs the question, where do you look next? Higher taxes, or from a gaming perspective, do we start seeing more and more VLTs? That's, I think would have less issues with the Wire Act potentially, and that's something Illinois has experienced with a lot of cannibalization to the existing gaming business. But, you know, like net, the materiality here for these larger, very diversified gaming operators and technology companies right now is not huge, but it does beg the question 10 years from now, 20 years from now, this is the future, and it's concerning. So there's a lot at stake here, I think, in terms of a longer term outlook, whereas maybe less in terms of the near term model, let's say.
I remind everybody, I know we're getting several questions in, and I'm going to turn it over to Eva here now that may have some of the questions from the audience, but if you have ones, please type them in your window, and we'll get to them with our panelists here. So Eva, do we have any questions we want to address the panel?
Thank you, Brendan. Yes, we do have a lot of questions, and they keep coming in, and I want to apologize just at the beginning because most likely we won't be able to address them all. But here is one. coming from one of the listeners who said, I think we are on the call because a lot of us are attorneys and we operate under the policy of hope for the best, prepare for the worst. What are the worst case scenarios then and how to prepare for them? And I will ask Tony perhaps first.
Sure. So, the worst case scenario is the Federal Wire Act is a criminal statute, and the worst case scenario is the Department of Justice could bring criminal charges against either operators or suppliers that are involved in the industry, and obviously it's a felony, so that would be of great concern to anybody who actually gets charged. So that's probably the worst case scenario. The best case scenario is what I described before, and that is, the industry and the states get ahead of this by, in the next 90 days, bringing an action to invalidate through declaratory relief the ruling. That just makes so much sense to me that any other path, I think, is fraught with too much danger to the suppliers, less so to the states. I agree with that, but to the suppliers who are involved in the industry, and frankly, the payment processors are going to have to make a very hard decision whether or not just to withdraw from the industry. And in many cases, if not most cases, this is a small part of their overall revenues. So that decision might not be as difficult as one might suspect.
Okay, thank you. Does anyone else would like to comment? If not, so another question is, I think, for Gordon. I did hear that Mega Millions was mentioned. So the question is, considering that Mega Millions and Powerball have operated on a wink and nod from the Wire Act, will this re-establishment of the original intent of the Wire Act stop these games?
Well, obviously, we don't think that's the case. We think the original Wire Act applied only to sports betting and not to the multi-jurisdictional games, which have been around for decades, by the way, predating any of these rulings and certainly even to some extent predating the proliferation of the Internet. But as I mentioned earlier, I think the multi-jurisdictional games, by being multi-jurisdictional games, don't in themselves create a separate legal challenge any different than an in-state lottery game that also has basically the same payment processing and data retrieval mechanism as any other game. So there's certainly highly visible games. I don't think there is something specific to them, though, that would allow an enforcement mechanism to isolate them in a separate enforcement mechanism that was different than just basically trying to shut down a lottery.
One thing that we haven't talked about, and this goes back to the original Wire Act in '61, is obviously it applies to sports betting, but obviously there's a pari-mutuel side to this. In a worst case scenario, how could it potentially affect the pari-mutuel industry?
Well, this is Tony Cabot. It could significantly. Let's keep in mind that the same Department of Justice, if you want to go back to their earlier opinions, have said that the horse racing industry is A, clearly subject to the Federal Wire Act, and B, something called the Interstate Horse Racing Act does not give an exemption from them from prosecution. And the reason they said that was because the Interstate Horse Racing Act, which effectively requires betting operations to pay the track for the right to take bets on the races at the track, is a civil statute. The Federal Wire Act is a criminal statute. Criminal statutes take precedent over civil statutes. Therefore, the massive industry, internet wagering industry on horse racing and common parimutuel pooling would, under prior interpretations of the Federal Wire Act, be illegal. And so if they're going to enforce the Federal Wire Act, if they're going to enforce it equally, which is doubtful because Mitch McConnell's from Kentucky, it would apply to the parimutuel horse racing industry.
Eva, do you have another question from the audience?
Yes. So actually, there's a question here for Tony specifically. Is interstate data transmission in wagering information or odds or remote risk management at risk after recent opinion?
Sorry, can you repeat that again? I just missed the last part of it.
Is interstate data transmission of wagering information or odds or remote risk management at risk after the recent opinion?
Well, so we have to be careful because the Department of Justice said that information assisting in the placing of bets or wagers on any sporting event is covered by Part A of the Federal Wire Act. But there is an exemption under Part B of the Federal Wire Act, not for bets or wagers, but for information assisting in the placing of bets or wagers between states where it's legal. And so arguably nothing has changed with regard to, let's say, risk management between the states where, for example, sports wagering is legal. So I'd be less concerned about that than I would about bets or wagers or communications that allow receipt of money based on bets or wagers, because there's no exemption under the Federal Wire Act Part B for those activities.
Great, thank you. Now the next question. Once the new AG is confirmed by the Senate, does the panel believe the opinion could be reversed? And I'm just putting it out there to whoever wants to take it. Anyone?
I'll step in. I'll step in off of that. This is Brendan. I don't see, at least from our perspective of looking at this from a global market advisors and a government affairs perspective, I don't see any change in the foreseeable future off of where the Department of Justice would lie on this. I think that any changes would have to occur under a different administration or, as we've discussed, anything that would happen through the court system or legislatively, which I think will be a stretch at the congressional level, considering we're on day 30-something of a shutdown.
Hey, Brendan, Brand here. Let me follow up to that and sort of ask the next question, which is kind of, that's a very interesting question, Ava, because, you have to look at this from a legislator who's proposed legislation that deals with this. It's very popular with constituents. This is a populist issue. And at the end of the day, we have a president who has been elected by running a populist campaign in the past and potentially, running for re-election on that same populist campaign. Do you think that changes it at all from your DC perspective?
You bring up some very valid points there. And, I think that you have a mixed message, if it would be the best way I could say it, in that you have a current administration that's very much said it's about state rights. You've seen that in several of the actions. And then There have been niche things along the way, both memos that come to mind is not only this one that occurred in January, but the one that occurred in January of last year with regard to the marijuana issue along the way. I don't necessarily have the best answer of where things go off of that, other than to say that it's a mixed message, and I'm not sure where things will lie in the future ahead. But there definitely is a message of states' rights out of this administration, and this is, I think, a little bit counterintuitive to that effort.
Yeah, I agree 100%.
Okay, thank you. Moving on to our next question. So there's obviously quite a lot about payments. That's very topical, and you have all discussed it already. Here's a question again about payments. Considering all payment processes leverage consolidated infrastructure, if this interpretation applies, it wouldn't be possible to fund interactive or sports sites. To that end, what would constitute an intrastate payment? And I think this is again for Tony.
Well, so I'm less worried about whether or not the payment is intrastate or interstate, as I am about the fact that the payment processors have to do due diligence, know your customer with regard to who they're dealing with. And if they believe by virtue of this opinion that providing services to any type of internet wagering, or even in that case, mobile wagering, would be in contradiction to the new opinion, I think their hesitancy, regardless of whether it's interstate or intrastate, I don't think they're going to get into those types of details. I think what they're going to say is, we don't want to get had the potential of a legal action brought against us by the Department of Justice, whether it be for civil fines or criminal penalties, because they are alleging that we're aiding and abetting an illegal operation. So, I'm not so sure they're worried about the intra versus inter with regard to the payment. They're worried about who their customer is and what they're doing.
Okay, so go on.
Just add to that, and again, for the payment processor's perspective, my guess is that there's a lot of interstate back-end processing that occurs, and so that distinction, just to back up what Tony just said, it really doesn't mitigate their risk.
Thank you. Right. So going away perhaps for a little bit from payments, there's a question, and I think I will ask Barry to give us his opinion. Barry, what do you think? Because obviously you talk to investors. How will reflected what is the impact on the European operators and the European companies' appetite to enter the U.S. market? Doesn't this new development put kind of a stop to their ambitions or to their desire to enter the U.S.?
Sure. Well, look, I think the European bookmakers, operators are all facing somewhat internal challenges in their home country relative to regulation and taxes. So I think the U.S., this certainly is a concern and something they need to better understand, but I don't think this alone causes them to pack their bags and go home. I think they still see the potential here. If there's sort of a worst case scenario, then there's a lot of issues for everyone in the U.S. But if it's simply cross state pooling of poker, let's say, that's fairly immaterial. If you look at New Jersey, it certainly gives promise for the future down the road, but I think there's still if it's more a best case scenario, there still is a reasonable market, certainly within sports betting, which would have less of that cross-state pooling issues, assuming we're not talking about the infrastructure and the internet and more communication perspective. So I don't expect them to pack their bags anytime soon.
Thank you. Now, we also had a couple of questions about affiliates, in particular, regulated affiliates, and what they should be expecting, and whether there is an impact on their business, and as well on their ambitions to enter and also grow in the U.S. market. And I am going to, I think, ask Tony to address it, if you can, Tony.
Sure. So the affiliates, as a legal matter, if the operations to which they're supporting are illegal under this interpretation, they would potentially be aiding and abetting an unlawful transaction by providing affiliate services. But practically, they're kind of far down the line, in my opinion, and would, as a practical matter, probably be one of the lower on the totem poles in terms of potential federal action, whether it be civil or criminal, to enforce this new interpretation. I think the more direct suppliers, the people who are providing the software and the people who are providing payments and payment processing and those things would be more in the potential crosshairs.
Thank you. What about offshore sportsbooks and offshore operators? While the DoJ opinion may impact operators' license in the U.S., what about those offshore operators? Will they still have relatively easy access to U.S. customers? And which body has the potential to try to block offshore operators?
Well, this is Tony again. Let me give a brief answer to that. One of the significant problems that I think that the federal government has is that the number of enforcement actions against illegal offshore gaming sites is insignificant and has been going down for years. You start attacking the regulated industry unless you have a corresponding increase in both enforcement from the FBI and prosecution from the DoJ. The only effect you have when you make these type of decisions is to drive the gambling to the illegal sites.
This is Barry. All that I would add to that, I think that's spot on. I mean, just because you legalize online or sports betting doesn't necessarily mean all the illegal action will shift over on day one. The product has to be as competitive, and it's harder when your margin is impacted by taxes, integrity fees. Start adding to that cost layer minimally by starting with forcing all the servers in the state, additional headcount. It just gets harder and harder. And, so it's a real issue and sort of slows down the shift from illegal to legal, which is primarily, a real motivator in terms of this, the legalization here.
Great, thanks. I think we have maybe time for one more question, which I am going to ask Brand. I think we have talked a little bit about it, but here's the question. Shouldn't the state begin legal action to protect use of the internet for fundamental games like Lotto? That seems more urgent than expansion of internet gaming.
So let me just get the question right. So the question is, shouldn't the states take the initial action to respond?
Yes, and to protect the games that are already offering?
Yeah, sure. And the way that I can really answer that is we'll see. However, the answer is probably likely no. And because if the federal government isn't going to take the initial first step, it's their opinion. The DOJ put the opinion out. The onus is now on the federal government to come after and try some sort of enforcement action with the state. I believe Tony referenced this a little bit earlier. Sure, it would be, for academia purposes, easier if the states were to just step up and respond quickly by trying to secure their rights. But from a state perspective, why spend the money? You're dealing with states that have already got budget implications, that are already worried about budgets, that are already trying to balance their budgets and use those tax dollars most effectively. They're not just going to jump into a lawsuit just because. If the federal government just wants to put this out here to satisfy perhaps certain stakeholders that have invested in some sphere of politics, fine, so be it. If the federal government isn't going to take any action, then again, we respond to it similarly like we do with marijuana. We continue to promulgate our rules, we continue to move forward, and we're going to have robust operations that bring in revenue.
Thank you, Brian. I am afraid that's the time that we have for this webinar. I wanted to thank the presenters again for agreeing to be part of it, again, at such a short notice. Obviously, a very topical theme reflected in the number of registrants that we've had and that we managed to keep. I'm really sorry we have not been able to go through all of the questions. We will try to answer them in a follow-up email, perhaps. Please do watch out for an email from us about ICE North America. We're just about to release the agenda. But also, we hope you will tune in to our future webinars. Again, watch out for an email on this from us. Thanks again, and have a wonderful weekend.
Thank you all.
Thank you.
Thank you.
Thanks.